Well, the stage has been set for a massive legal battle around the release of Thuli Madonsela's so-called legacy project, the State Capture Report. The North Gauteng High Court is expected to field a full bench of 3 judges to hear arguments for and against the publication of the State Capture Report. Leading the parties in opposition of the State Report release is President Jacob Zuma. He'll be joined by Ministers Des van Rooyen and Mosebenzi Zwane, who have each filed interdicts in court papers. And today is the latest round in a war of words between President Zuma and former Public Protector Thuli Madonsela. President Zuma says there was no attempt at a fair probe into state capture allegations, and he was given too little time to respond to the questions. In court papers, the President says he was not afforded his right to access possible incriminating testimonies and to cross-examine witnesses. And President Zuma alleges that processes were flouted when he was not informed of the possibility of being implicated. Also, he's red-flagged the apparent haste to complete the report despite the receipt of an interdict notice. However, the former Public Protector says President Zuma did not cooperate with the probe by frustrating her attempts to follow up on her investigation. She also says it's not true that President Zuma was denied opportunities to exercise his legal recourse to respond. Furthermore, the current Public Protector and herself are at odds on the issue of the state capture release. Well, let's take a look at some questions that the court will test this morning. In finalising the report, did Thuli Madonsela rush the state capture report, and did she ignore the process of her office in doing so? And does it follow that because Madonsela finalised the report, could she be compelled to release the findings? And will it be possible to have the state capture report set aside if it was found that due process was not followed? And if allowed access to witness testimonies, should a fresh report be compiled with President Zuma's responses? Now, the following questions posed by the President's lawyers will be brought before the court for consideration. Did the ex-Public Protector finalise the report despite receiving an interdict notice from the President? Now, was the President informed that he's likely to be implicated in the report? And did the ex-Public Protector have reasonable time to finalise the report between the 11th and the 14th of October? And is it obligatory that the Public Protector's office to share the report with those likely to be implicated? And is it obligatory for the Public Protector to allow cross-examination to access the evidence if the implication is likely? Let's go now live to the High Court, Gauteng High Court in Pretoria. Calden, good morning to you. I guess what kind of support have we seen there earlier this morning?
Well, good morning, Peter. Not really much happening here apart from the media that's already starting to do their first live crossings here from North Gauteng High Court. Apart from the media, lots of police presence here, but of course there are no protesters or supporters for Zuma and Public Protector here. But as always, we do know there will be more people coming in. EFF has already announced that they will be protesting outside the High Court, and we are also expecting other people, the civil societies, to come out here in their full, some of them, of course, supporting President Zuma, and some of them saying that hashtag Zuma must fall campaign. Those people will be coming here anytime. This morning, media has been told by the Office of Chief Justice that we'll have to be seated inside the courtroom by at least 9:45, and they're expecting a whole lot of media contingent as well as the public to participate here, Peter.
Right, Calden, basically let's try and summarise all the parties, some of the parties' responses or matters in this. We've seen in the last 24 hours that the Mineral Resources Minister now is going to be, or has filed papers to try and stop this report as well. There certainly are 2 clear camps in this matter.
Exactly, Peter. In the last few weeks, we've seen just the number of people increasing as far as this state capture report is concerned. Today, we do know that Zuma's legal representatives will be making their submissions and they will be seeking for a postponement. But we do know EFF, DA, UDM and COPE will be participating as well. And very surprisingly, Mineral Resources Minister Zwane came into picture yesterday when he says he's filed an application to interdict this report, and he says along with Minister for Kokta Minister David van Rooyen, who was initially involved in this as well, where he had applied for an interdict and then again withdrew his application, stating that he may not be implicated in the state capture report, only to be told 10 days later again that he is refiling his application as he thinks that the previous public protector Thuli Madonsela did not give him the right instructions. And he said that the new when he asked the new public protector on whether or not he's implicated, he said she has neither denied nor confirmed, therefore he's going ahead with the applications. So we will be seeing that, we will be hearing what the judge has to say about Minister Zwane as well as Minister David van Rooyen as well.
Now, Kelton, there's a lot of question marks over timing in this matter. Was the president afforded enough time to answer all the former public protectors' questions? Is he playing delay tactics? Is going to be another point that the opposition parties are going to be playing on this. Timing and dates are going to become important in these applications.
Well, Peter, there's been many arguments regarding the timing from day one when this matter was brought to the court, where President Jacob Zuma has always stated that he has not been given enough time to reply to the public protector's report, and also question of whether or not this state capture report has been finalized or is it still at its preliminary stage. We've heard a former public protector Thuli Madonsela stating that the report has been finalized, is signed and sealed and kept aside, but Jacob Zuma has always said that he's not had enough time to reply to the written questions. He has not had the opportunity to question some of the witnesses that former public protector Thuli Madonsela took as her witnesses. So he's always complained about time from day one, as well as Minister Zwane and Minister van Rooyen, who comes into picture here, who also complained that they've not had their own fair share of time, and this has not been done in a proper manner. So they needed more time to talk to these witnesses, cross-question these witnesses that have given evidence to former public protector Thuli Madonsela, stating that they need to look into this matter deeply, as it's a matter of concern. If the this state capture report is out, it will harm their identity, it will harm their position that they are taking in right now. Now remember, this is a very high-profile case which involves the president of the country. It's not just a common case that we see on every day of our lives. It's involving President Jacob Zuma. It's implicating two ministers, Kokta Minister David van Rooyen as well as Minister Zwane. So they've said that they've asked the court to look into the matter very deeply, and we cannot really come out of this report if it's not completed. But there are other various political parties like DA and EFF coming out and saying that it's a delaying tactics by these team, President Jacob Zuma and his team. They're just going round and round talking about that the report has not been finalized. It's still incomplete, when public protector has already mentioned earlier that it is finalized, signed and sealed and kept aside.
Kelton, thanks very much. We'll be back with you a little bit later on there. Kelton, live at the North Gauteng High Court in Pretoria. Well, for more legal analysis on what could transpire today, joining us on the line via Skype, legal strategist Richard Chimali. Richard, good morning to you. Just to describe to us now, in terms of this actual report, I mean, the Public Protector Act is very different to some of legal acts. I mean, this is all about a fight between getting this Public Protector report released and not. It's actually not regarding the actual contents of the report.
So that is the gist of it. I mean, obviously, the public sector and civil society and opposition parties want to have access to this report because it's very juicy. But there is a long-standing rule in South African law which isn't really echoed in the Public Protector Act, which is the Audi Ultram Partem rule, which I suspect is what Zuma and his camp are going to be arguing for today. And it just basically means hear the other side. It's long-standing and permeates throughout our law, and it's never been tried and tested in the context of the public protector. So it would be interesting to see that. I don't think it's going to be a winning case that they make, but time will tell.
When you say they, you're referring to the president?
Yes, the president's camp.
But I mean, let's talk about that, this Audi Alterum Parte rule. I mean, it's clear that the president has not had a chance to question, and it's an interesting, this Public Protector Act, the fact that you can question witnesses in this. This is not like going to a court of law where you battle it out there. I mean, you get a chance to have a look at those submissions made by people who are implicating you, and you can actually interview them. Is that right?
No, not necessarily. I mean, and like I say, it's never been tried and tested. What the Thuli Madonsela used to do, which wasn't necessarily obligatory on her, is that she used to send the draft reports to the people being implicated, and that was out of her own volition, just so to ensure that they are able to question certain things in the report. But it doesn't necessarily mean that they were able to interview witnesses. Now, when you go to an actual court of law, you're entitled to cross-examine witnesses, and we know this, we see this in courts all the time. But it's never been the case with the Public Protector's report whether or not you're allowed to cross-examine witnesses. So it creates an interesting sort of battle that we're going to see play out here. This is, of course, if this is the point of view that they're going to take, which they probably should, because it's probably going to be the president's strongest case that he can make.
You say the strongest point is the fact that he thinks that the report is incomplete and it shouldn't be released if it is incomplete, yet the Public Protector, or the former Public Protector, said it is complete.
And so too did the new one, but it's up to, I suppose, interpretation. If the president is worried that it's not complete, or he's worried that it was a rush job, then, you know, we've had this battle before where the Public Protector's reports are able to go through a review process in the court of law. So it may well be that the report gets released and then the president is entitled to review it. My suspicion is that they're using this to delay access to the report because there are some serious implications in the report. One's that he might either not be able to fight in a court of law on review, or more likely, I suspect, that they will, on fighting it in a court of law on review, lead to release of further information that possibly the president's camp would not like to be released.
Well, that would make the report incomplete, Richard, surely?
Well, absolutely, but that doesn't necessarily mean that we can make that claim right here, right now. It's left to the Public Protector to be able to say, I believe this report is complete. That's the prerogative of the Public Protector. And if the president or anybody disagrees, then the president or whoever disagrees is entitled to take that report on review. But again, and this is the strategic part of using the court of law in these sort of political issues, is that once it goes to court, then you have to, on discovery, start releasing all sorts of documents that relate and pertain to the alleged incompleteness of the report, and that might be quite devastating depending on what the content of that extra material is.
Richard, let's just talk about the report. I mean, is it not fair to have this report given to the president? We know it's under lock and key at the moment, and it's supposedly a final report. But I mean, should it not be fair? I'm just talking off the top of my head that the report should be released to him so that he knows. I mean, he is the implicated person here.
Absolutely, and I'm not privy to whether or not the president has seen this report, but generally the method is that a draft final report is handed to the implicated person or persons, and they're entitled to have a look at it and then converse with the Public Protector and say, this is wrong, check this is wrong, check this is wrong, check this. And it's not the prerogative of the Public Protector to accept the representations where the implicated party says that they find things that are wrong, but it is up to the Public Protector to consider the representations made at the final hour by the implicated person. So I'm not entirely sure whether that happened. I know that was the modus operandi of Thuli Madonsela in her days. So I suspect that it should have happened. Whether or not it did, I can't say.
Let's just go back in terms of the whole Public Protector Act, in terms of her recommendations, because those are what they are. I mean, what we've seen in the Nkanda report is that those recommendations would be binding. Are we likely to see recommendations in a report such as this at this stage?
Well, I would love to say yes, because that I find it rather arbitrary to simply just put out a report and then say, okay, leave it in the air, leave it for somebody else to decide. But like I say, none of us have really seen this report, so we can't, put money on it. But I would suspect that there would be a couple of recommendations, and whatever those may be, I'd love to see what they are.
Wouldn't we all? Thanks, Richard. That's where we're going to have to leave it there. Legal strategist Richard Chimeli there on the line via Skype.